the speaker was Chester Soong, and it's kind of funny though. When we're talking about organizing this tutorial, and we're thinking about him, and at the time he's in the Spain, right? Yes, and he suddenly received an email from us that say you have to come here to do the contribution. So he actually, when you are fly from the Spain to here, 2 days ago, last week. Last week, okay, good. Let me first of all introduce the Chester. Chester started his own ISP back to the 1994, and he worked for the Citibank, and as a project officer before the Chester graduate from the California State University. And then, of course, it seems like he's getting interested into the legal issue. And so he continued to working on the summer course to learn more of the legal. And then Chester is a frequently speaker in a different region, conference seminar, particularly in the IT development and information security. And he was formerly of the director of the certificate services for the Asia Pacific region, and first to pass the CISSP exam back to the 1997, kind of long time ago. Yeah, very long time. Yeah, and he's a technical advisor to the employee retraining board of the Hong Kong SAR. I don't know what is ASR. It's a government,
Not important.
Not important, okay. And then the chairman of the Internet Society and the council of the member of the Internet Security and the Financial Society too. And now we give the session to the Chester. Sorry, Chester. He called me Huawei, and
I think Charles was right. I mean, you don't need alcohol to.
Okay, Chester, your turn.
Thank you. Well, can someone bring up my slides? Yes.
Yeah.
Well, thank you, Huawei. I get it right. And of course, TWIGF and APRGF to invite me to speak here has been an honor in this. And I used to be on the MSG and really missed everybody at the conference itself. And so yeah, but it's actually it's tough because I have the after lunch session. Yeah. So and more difficult is the topic. It's like this is like a heavy dose of sleeping pill. GDPR like sleeping pill equivalent. So so I'll try to keep you guys awake, but or if you have any questions, please jump in, and I'll try to leave some questions at the end too. So let's begin. So I think Ken-Ying, the last speaker, one of the last speakers, mentioned about the GDPR already. So okay, it's probably one of the most consequential legislation or law in the privacy space, or anything related to this topic in the world, because of its reach, because of its weight. So I'm going to touch on what it means and the basically try to boil down the many pages of the regulation into a few PowerPoints and to talk about it. So I guess for some of you may actually know a lot about it already, so you can skip it. But but then I'll also try to insert some recent cases that you will be able to see how the law is being actually enforced. And then I would just barely touch on the new law that we have in the EU, the AI Act, which was fresh. It's fresh out of the oven. I mean, it's really fresh. This since August 1st, is being enforced. I mean, released or published. So anyway, okay. So a bit background on the GDPR, on the regulation. So as Kanying mentioned briefly in her slide, that we have maybe someone would like to categorize the privacy policies into 3 main geographical style, or maybe framework. And so the EU one, the GDPR, the regulation, is really based on the Charter of the Fundamental Rights. So it's basically human rights based. Okay, so everything that they believe should be protected, to be enforced, how it should be processed, basically the idea came from that. And then, of course, the predecessor of the regulation will be the Data Protection Directive, right? So that was released in '95, and then the GDPR was released in '16, but it was not really enforced until the 18th. So when it applies, when does the regulation apply? Now, basically, you know, I'm not going to explain it line by line or word by word, but we all know what is personal data, but the regulation sets a very low bar on what it is. So it doesn't, it goes way deeper or lower than your name, your address, your ID number. It talks about anything like identified or even identifiable natural person. So that means like your email address, your IP address, your geolocation, all these data, or even which I'm going to talk about next, like your political belief, your sexual preferences, those are also personal data, or they take into that effect. That's the level that they're saying at, right? And processing includes collection. All right. Now, for example, when I used to work briefly at the privacy commissions of the Hong Kong government. So in our law, the PTPO, we do not require consent in data collection. Okay, so that may not be the case. I mean, so and usually we kind of separate collection in a separate action in terms of processing. So processing, especially for us with a technical background, processing is something you do after you collect the data. Okay, but from the GDPR's perspective, processing is the collection is part of it. So for the controllers and for the actors in that is addressed under the regulation, the controllers and the processors, when you talk about data processing, it includes the collection of the data itself. And when you have that collection, when you conduct collection of the data, it requires, there's a specific set of rules that govern the collection of it, or this processing. And also, I guess part of the reason why GDPR was so famous globally, because of its extraterritoriality. So it's enforceable beyond the EU. Okay, like, so basically it doesn't matter where your company is, as long as the data subject resides in the EU. Like, for example, I am not a Spanish citizen, but I'm a resident in Spain. I am protected under the GDPR. You know, so that's why, and you know, so it's this is very different from, I guess, many other similar privacy regulations from other countries. And okay, so when it applies and when it does not. Okay, now there are a few areas or few exceptions that the regulation does not apply. It's first, anything personal or household activity. What are they? Like for example, if you send an email to your sister talking about like your mom, or telling her your wife's telephone number or email address, or where she's staying for the next 6 months or something like that, that's totally your own issue, your personal and household issues. Okay, but again, that's a very narrow definition. All right. If you've another example, or the opposite example would be like if you have a security camera outside your house monitoring, to detect burglars. Okay, that is not that's more than your household activity. Okay, that's not, so that would be governed under the regulation, right? It does not regulate national security, and also you can imagine when we talk about privacy. Remember, we're not just talking about personal data. Now, a lot of privacy laws, especially like, for example, the Hong Kong one that I used to enforce, we basically talk about personal data. That's why our ordinance is called personal data, privacy ordinance. It's not privacy, personal privacy. It's not like that. Even our so you can imagine, like, if we talk about privacy, it can be in conflict with other fundamental rights, such as freedom of speech, public interest, other freedom of expressions, things like that. They can be in conflict. So, but then it really, the GDPR really, gives strong examples to the member states that they should balance these rights. Okay, so even how powerful you may believe the GDPR is, it's or can be, it doesn't take other rights. Okay. Yeah. So this is one of the case law that I was trying to reference in this. So basically, you don't have to copy this because I have send the slides to the organizer, and then I have the reference case in there. Basically, what this is back then there were a few cases that the regulation or the data protection authorities, they had complained about the processor, the controllers, for retaining too much personal data for too long. Okay, and some of these were about the storage requirements. Some of these were about anti-money laundering schemes. So at the end, so the European Commission filed a complaint actually against the regulation that they cannot preclude national laws on the protection of like national security or serious crimes prevention detections. Okay, so it doesn't, and it also doesn't come before the charter. The charter is the Charter of Fundamental Rights. So it doesn't power the fundamental rights requirements. So okay, now what's allowed under GDPR? I mean, it's the regulation wasn't created to block businesses to come into the EU, obviously. So what it must allow something to happen, and so basically it's based on like the FIPs, Fair Information Practices. That's where actually the Data Protection Directive was based on. when it was drafted, this is what it was based on. So we have all these requirements that you just have, but you have to define them so that you can use the data, right? So it has to be lawfulness and purpose. You have to limit your purpose. You have to minimize your collection. You have to make sure when you are the controller, you have the responsibility to make sure that personal data that you process is accurate. And then the data subject can make a request anytime to you, to the controller, to ask like what personal data you have on me, and to make sure that they're correct. If they are not outdated or they found it's not correct, then you have the responsibility obligation to correct them. And then you have to enforce, also implement technical and managerial measures to protect the data. Now, in many other security, privacy laws from other countries, you may find that you have provisions that describe the requirements of the technical measures, the security measures to protect the data. And usually, that's usually they just require you have the controller has to implement security measure to a reasonable and feasible extent, because like you can imagine in a way, if you are a very small tutorial company, like the teaching kids to like giving lessons for math to primary students, primary school students, right? You may not have a big budget in IT security, okay? So how much do you expect them to invest in a firewall or in other security measures? So you may see this kind of provisions in certain kind of law, including the one in Hong Kong. That kind of gives a flexibility in terms of protection or the level of implementation to the controllers. But this is not the case for the regulation. Basically, what the expectation of the regulation is, you should invest or you should implement the best available technology to protect the data as possible. So whether you can afford it, well, now I wouldn't say they don't consider that as a factor at the end, but the law itself it actually requires the other way around. So the processor or the controller have the responsibility to make sure that they implement the best technology available. So this is something very different. So when the past 2 years I was helping, when I was in Spain, I was helping a charity organization, very small one, based in the UK, to set up a website and basically to broadcast certain educational content, right? So I was helping them to draft their privacy statement, and then I was looking at the privacy law for the UK and also GDPR, and to be honest, luckily we didn't have to collect a lot of personal data, and we didn't have to process very sensitive ones. Otherwise, I'm really not sure how such a company or organization can afford a full compliance. Yep. So again, so you have to, and you have to have legitimate ground to process the data, right? So all these you have to, and all these all these points that I'm talking about here, they have to be explicit, okay? They have to be not on paper, but it has to be seen. You have to be you have to receive explicit consent, agreed by the data subject, for you to be able to process it. Okay, so you have to do that. You have to, and then you have to have contract to talk about it to describe the processing, all the terms, or they must be something as important as like it's life-threatening. It's also has to be of public interest, but it's not simply a gossiping public interest. It has to be very like significant public interest. And about consent, actually I was earlier this morning. I was just reading a fresh judgment by the Italian DPA. A telephone company was fined €1 million for simply calling their customers without consent for marketing calls. I think it was about for Italy I'm not sure about time if you have a no call list in Taiwan or yeah.
Private.
Or telephone
We try,
marketing?
but doesn't work well.
Okay.
Yeah, I can talk later.
Yeah, so in Hong Kong we have one too, but it's not directly linked to the Privacy Commissioner. But so in this case they have a no call list. Okay, so this telephone company they have two or three sets of calls. One is incoming call from the data subject, so that's okay. Just that you call them. The data subject initiated call, so that qualifies consent. But the other two, which is direct outgoing call from the company. The other one is through a web page, which the data subject has accessed and left with certain personal data, including the telephone number. So that means the telephone company, as the controller, has the obligation to check the no-call list, and they didn't. So, it was some of the data subjects filed a complaint, and it was ruled actually in June, a couple of months ago, that we were fined €1 million. So, pretty expensive call. Oops. Okay, and now I talk about personal data. From the regulation perspective, it separates typical or general personal data, such as name, address, telephone number, all these with another set of data that they classify as sensitive. It means like your racial, ethnic origin, your political affiliation, your religious beliefs, health data. All these are in a separate category, which require a separate set of even higher bar of rules to be processed, and the consent or the consent requirement would be even higher. So that means you have to, as a controller, you have to explicitly ask for special permission for collecting and processing this kind of data. So it must be separate from the general personal data that we talked about before. And so unless it's required by the operation of the controller, like for example, hospital, healthcare systems, then obviously they need your health data, your medical records to be able to save your life or to give you proper care. So this would be acceptable. This would be allowed. Yeah. So and then also, if you are talking about public interest, it must be substantial. That means the public interest is to what extent? Like, for example, if you are talking about a public figure, like a politician, like, for example, just few months ago, the wife of the Spanish president was involved in on a scandal, money laundering. Well, they didn't really say money laundering, but she receives certain monetary benefits. So everything was made public, you know. So and so this is again. So this is I guess this is one example that how the substantial means when you try to process personal data or sensitive data to that extent. And of course, if you are a politician, you kind of, I wouldn't say give up, but it's required to really make public your, say, political beliefs, your preferences, and things like that. Okay, the other thing is data movement. Okay, so when a controller wants to move your data out of the EU, it has to meet these requirements. So either you can move your data to one of these countries or jurisdictions, but there are only 7 of them. Okay, so and not even the US is in it. So and some of you may have heard about the safe harbor provision, right? But that was overturned a few years ago by the court. So that's why now we have sort of a replacement called Privacy Shield. I'm not going to go into the details of it, but basically you replace what was more of a blanket approach, the safe harbor provisions, with company-specific or organization-specific requirements that each of these organizations has to sign or basically promised the same level of protection within the EU, right, to be able to process, the personal data from a EU residents. Yep. So, what are the other responsibilities, right? So we talk about the controller has to issue consent or has to make receive consent from the data subject before they can collect or process your data, and then basically the controller must have a very detailed plan and procedure in the whole collection, processing, and storage process. It has to be in detail how the data is used, when it's used, who would have possession of it, or whether or not it will be passed to a third party for processing, like a processor, all right? So, and then one of the other major requirements that the GDPR introduced was privacy by design and by default. So that means when your company needs to process personal data, the whole collection process, the processing of it, the storage, how it's used, the whole thing, it must be carefully thought out at the design stage, at the very beginning. Like when you say you like I was using a tutorial center as an example. So in order for you to provide math tutorial classes to primary school kids, what what's the minimum personal data you have to collect from the child and also from the parents. Okay, and if anything that's not absolutely necessary, you must not collect. You must not process. Okay, so, and then, and it has to be well thought out from the very beginning of this business process. So that's why a lot of time when we assess such a system, we would not, the IT system, the technical system is actually the last thing we looked at. The first thing we did would begin with an interview with the business operation, see how how the whole flow is carried out, okay, and where in which specific point that security should be there and is it there, okay? So or even are they adequate, okay, and so by default is really it take it to another level where you are assumed as a controller, you are assumed to take all this measure, you know, to the highest standard. Okay, so it's not like you can okay, well I can't really be sure if I need the address of the student, but maybe I need it someday, and then let's collect it first. Let's collect it anyway. You can't do that. Okay, so and also you are required to have a DPO. Okay, now before the regulation, DPO was a recommended role. Okay, now for some strange reason, I was the DPO of the Hong Kong Privacy Commission. I don't know why they didn't name my boss, but anyway, so now this role in particular has to be independent from the operation, and technically speaking, this person is almost like a judge in a judicial system where he cannot be liable for his advice made to the company. He cannot be fired because, like, oh, he rejected the idea of collecting a certain data point because this might violate the regulation. Okay, now practically, I don't know how that would work, how that could work, but yeah. So and supposedly this is a specific position in the company. Okay, so although many organizations you would see usually if they have an in-house counsel, that person would also be the DPO because he or she would be I guess legally capable of or better understanding in terms of the requirements. And if the processing kind of high risk, that's the other thing about DPIA. It's like if you say you collect a huge amount of personal data, or the data that you collect is classified sensitive, as I mentioned earlier. You have to conduct a data privacy impact assessment. Okay, I remember when I finished my LM, I did my dissertation on PIA, how if PIA would actually help to enhance policy. So I studied basically all the privacy laws from every country that I could find, and there was actually none at that point. It was, I think it was 2011. Yeah, it was 2012. Sorry. Yeah, so at that time there was no country required TPIA to be conducted. Okay, at least not a requirement anyways, but this is now a requirement. So again, we talk about the technical and managerial safeguards, and then you also are required to notify your DPA within 72 hours of a data breach. Okay, so this is one of the mechanisms that the regulation has evolved from the directive that that all the controllers have to report to their TPA when they have a data breach, and that's 72 hours. Okay. And well, I guess I don't have to go through this one by one, but so this is, like I said, these are your rights, okay, as data subjects, okay. So you can request, you can make requests to your controller, your telephone company, your banks, your, you know, like why you're doing, what do you have on me, what you are doing on my data, etc., etc. And you can even ask them to remove it, okay? So that's the famous clause of the right to be forgotten, okay? So of course they even, I think they even use that in the regulation, but of course we in the Internet Governance Forum, so I guess we know enough that the Internet doesn't really forget. I mean, it's hard to make it forget. So yeah, and the other thing that it's it emphasized is profiling. Okay, so and it also made a very specific section. I mean, had a very specific section talk about automated processing. Okay, so you as a data subject, you can refuse. You can reject the idea of from the controller that you are being profiled, like what kind of a customer you are. Okay, you can reject that. So the other thing about the GDPR is enforcement. I think we probably know, some of us would know that it's it has I guess the significance of this is compared to the directive, the fine or the consequences of violating the GDPR is much bigger. Now, obviously, you don't always, and it's not the objective of the regulation to fine everyone until they bankrupt, but it's there, I guess, as a deterrent, right? So basically, you have an administrative fine that can be up to 2% of your annual revenue. And if the breach is serious enough, it can go up to 4% of your annual revenue. As compared to previously, like with the directive, I think there was a case in France against Facebook breach. They were fined for 150,000 euros. I mean, there's 1 hour of,
Did they pay?
Of course. I mean, if I would pay, I would pay. I mean, it's like cheap. And it's not, and it wasn't. So that, I mean, it wasn't even, I guess, a deterrent. I mean, basically, and I guess going back to the history of the GDPR and the directive, it was people in the field or in the private sector were kind of joking that the EU has rules, but there's no enforcement. Mm-hmm. Because not only the fines or the administrative fines was minuscule. It also didn't synchronize with the national laws of the member states. So basically, each country runs their own stuff. I mean, the directive is there, so you're free to, or you're encouraged to adapt, but or to create your own privacy law following that, but you are not required to have everything in the directive in your national law.
So that means have a many different kind of domestic law, or?
No, so I mean, at that time, you could. I mean, it was really kind of joke on the European Commission that like many countries, many member states, after the directive was launched, instead of promoting data privacy, promoting like how much we protect our citizens' personal data, they went out and sell to the tech companies. They like how safe you are to have your company in my country.
Yeah.
So this, this is how. That's why Google chose Ireland, to have the data center and have the office, have the presence there. I mean, they're
Meta also choose Ireland.
Yeah, I mean they had poor Ireland. They had the DPA. The whole DPA was half the it was half the size of my team in Hong Kong. I had 19 people working under me, and we had 80 in total for the whole Privacy Commission of Hong Kong. So, yeah. But anyway, but this is not the case anymore, luckily. And also now you may also see but of course the case is still there or the situation is still there that you may find certain countries have more resources in terms given to their DPAs to enforce the law, and some have less. Okay, but then when you have a case that cross jurisdiction, cross nationalities, the DPAs can cooperate and share information and to jointly investigate cases, which bring the whole situation to a different level, in terms of the controller against one tiny island DPA or versus many countries. And also, the European Commission and advisory board have advisory roles and oversees the DPAs in terms of enforcement. So when they see certain DPA or certain country is not doing its job in enforcing the regulation, they would jump in and intervene. Another example that I have here is but this is about, okay, when we talked about last time, we have this, in terms of enforcement, I missed this one. It's actually, so it also introduced a class action type of activity. For those of you who knows American law or US laws, correctly speaking, we can launch like small potato citizens like us. It's hard to go after or to deal with companies like Facebook or whatever. So, but then, so you have this class action lawsuits in the U.S. where you can actually group a whole bunch of victims, and then you can file one lawsuit against, collect the resources, and file one lawsuit against the big company. Okay, so this did not exist in the directive, right? So now the GDPR allows this to happen, and you can allow any non-profit organization to file lawsuit or complaint to any DPA on behalf of the victims or on behalf of the data subjects. So this is one of the cases where a German consumer rights organization was filed lawsuit against Facebook on behalf of the users. And in this case, the users, I mean the consumer organization did not even get or need to get, or the court at the end ruled that they didn't have to get consent or agreement from the data subjects to file the complaint. So, and of course, so so this is one example of such mechanism is put into place. So you can go to the Article 80 of the GDPR. You can look into the specific wordings, but so this is the background of it. Also, this is an example that the European Commission jumped in at another national level on their enforcement. Remember, we required, under the regulation, we required each country, member states, to set up the DBA, and the data supervisor is on a specific employment term. So there's a specific role, and basically, like I said, it's working like a judge. All right. So and for some reasons, I didn't look into why Mr. Jory was hated by the president or the prime minister or the government, so he was fired. Basically, we took a reform on their privacy law, and then they reformed their national data protection supervisor. So at the time, Mr. Jory was the supervisor, and then so he was not continued with the new organization that the government set up. So then the European Commission jumped in and say, well, you cannot do that. So of course, Hungary they appealed the advice. I mean, they did, so, but at the end, the CJEU, the Court of Justice of the European, which is the highest level of court for the EU, declared that they failed. So they had to now how Hungary at the end addressed this. I did not follow, or didn't say it, because so he was terminated. A new organization was formed, and can they rehire Mr. Jury? Not exactly. So now, but then they were actually, at least they were fined. I forgot for I think 100,000 or something. But then, of course, but the fine is only one of the judgment. They required to ratify that as well, and they had to pay for the costs for the European Commission and themselves. Okay. Now, I'm not going to really go into this, but like I said, this is brand new. I guess not just me, but I guess I'm not so sure everybody in the EU or even in the AI office know exactly what they're doing. It's a directive, so it's not. So a lot of area of the law is still at a high level. So, and it's not defined yet, and they're hiring. So if any of you are, planning to hope to work in the EU, you can apply. So they I think they said they would hire like over 140 people. So there's a big office. And so they would, but then in summary, briefly is, they try to separate, or they try to classify all the AI system by its risks, right? So they would have a sensitive or specific category of a system that are like manipulative AI system would be prohibited. Okay, so that's cannot be marketed in the EU. And then if you are classified as if the system is classified as high risk, then you would you'll be obligated to define a lot of things. You assist the design. You have to document the design, the instructions, and all this, to publicate, all these details. And then so now the elements that now this is, you can see the predecessor, of controlling this system from the regulation, where it started, it requires, or it has specific provisions talking about the automated processings and profiling, right? So this is one of the things that also they are bringing into the AI Act, yeah. So we'll see how this developed, but yeah, like I said, this is only effective 2 weeks ago or 3. So yeah, everything is still, a lot of things are still up in the air, and I guess they are still receiving comments and stuff. But one thing though is, I know the privacy supervisor, European Privacy Commission, privacy supervisor, the highest, technically the highest level of privacy supervisor for the EU, is also has an observer role at the AI office. So I guess that's what they are bringing into it as well. So so these are the references, which I think you can download my presentation online, right? Yep. Yeah. So.
Is this whole thing is online? And they can download? Or after the conference? Yep. Okay.
So I mean, so you can look into these papers and the cases and stuff. Okay. So I think this is the end of my presentation.
Okay. Thank you very much. And if anybody want to go to the microphone, please go ahead. And before you go to the microphone, I have a couple of the, my question for you now. Actually, Taiwan Taiwan have a data protection law. And the government actually tried to do the compliance with the GDPR. And of course, more than 5 years or 6 years, we still didn't work it out, because GDPR is very complicated than the Taiwan data protection law. For example, in Taiwan, the data protection law, we don't have an independent committee. Yeah.
Data processing authority.
Yes. So
the
there's a
protection
problem.
authority.
Yeah.
Sorry.
And that is one part. It's difficult to comply with GDPR, and the European allow to do that. And as I know, that Japan already did. Japan already have a compliance with the GDPR. I think that Japan is doing this is much better than Taiwan. But well, anyway, my real question is here. Before I retire, I actually doing the compliance stuff for the institution or company or governments. To compliance or doing the legal compliance, particularly the GDPR, is very costly. Not only by time, by human resource, by money. It's a lot of, you need to do a lot of work. And particularly, if for example, like a SME, small medium enterprise, they can afford it. And I think, of course, we are not talking about the GDPR in Taiwan. The SME talk to the government, say, if you want me to comply with this data protection law, even the Taiwan data protection law. I'm not talking about the GDPR yet. The SME is a really, they don't know what to do.
Yes, like.
And what about in Europe? I think they have a similar problem for the SME in Europe, right?
Yes, and from my understanding, like I said earlier, they did not come up with, or they did not develop the regulation to kill businesses, right? So, so part of the responsibility of the DPA is, or the DPAs, is to give advice to companies, to organizations, how they can comply with the regulation. So it's really part of the job to advise, to provide, to give advice, and to. So technically speaking, you can, for example, you live in Spain, you can send your request to AEDP to ask them, like, well, I have this operation. These are the personal data that I believe I will be collecting or using for what purposes. They would give you an advice on how to comply with the law. Now, can you fulfill everything that they suggest? Depends. And it will, like I said, I was helping with this non-profit organization in the UK, and I find it fairly difficult, because remember I said about the roles, the actors. Besides the controller, you have the processors. And the processor, you are basically, I mean, the controller is ultimately responsible for the processors. Even though they now, I mean, during the time with the directive, the processors are really kind of out in the gray area. Yep. So they were not really made responsible for their wrongdoings. So, you know, but now they are, but still, the processors can be separately liable, right? But then you, as the controller, technically speaking, you are the one who make the decision on all the processings. So you are still the liable person.
But since as you are in the Spain for several years, right? Yeah. From your experience, you look at those the GDPR. Is really down to the SME, or not really?
It can.
I mean yes. I mean, I'm talking about reality. I'm not talking about you can or you cannot.
Reality, yes.
Really?
I mean, you know, you wouldn't know how many cases I went through before you're preparing this presentation. I mean, it's like we have this cases. I mean, of course, I only read cases in the past 2 years from CJEU, which is the highest court, right? But then if you talk about national cases, we have cases that like a small company will fine 1,000 euros, you know, for their website not requesting explicit consent.
But 1,000 is okay.
Well, yeah, but still, no. Well, I mean, it's not a lot of money, but like you said, it's for SME, for a, I don't know, for a tiny company like making clothes repair. They still, I can imagine, they still need your name and your phone number. You know, technically speaking, that's personal data. They have to call you.
So they really did.
And so if you, I mean, like I said, they're not really out there to say, to watch over you and say, oh, you forgot to do this. They don't really do that. But so they're not really there to kill the businesses. But it can be done, and it could be done if you get complaint. They will.
Okay.
They will do things. Yes, but
luckily, actually, in Taiwan, in general, the people now always are looking for lawyers to sue.
To reflect on your earlier part of the comment is, I guess not having a DPA is probably one of the biggest problems.
Yep.
Now, of course, EU or Europe, continental Europe is a very different scenario.
Yeah.
I mean, you have so many countries, big and small, and then so you have country with a lot of resources. You have countries with little resources, and then you have countries that culturally very different from others. Like for example, the Netherlands would give a lot more a higher flexibility in terms of free speech.
Yep.
Versus Spain would be a lot less. So you have these differences in culture
but,
too.
I really wonder is.
But then at least you have an enforcer.
Okay, but I really wonder is the situation, particularly for the GDPR. When we're talking about the GDPR and regarding for the Chinese social platform, if you really enforce the GDPR and on the Chinese social platform like WeChat, many of them, they violate the GDPR. Then how the European can do anything about it? They cannot do anything, right?
No, I mean, personally, I don't use any of those platforms because I don't want to install anything from that source on my phone.
Okay, let me back. Okay.
Having said that, though, if they want to do something, they can. Like I said, the jurisdiction is not about where your country is. It's about, I mean, where your company is. Yeah. It's about whether you have European residents. You have to, residents in the EU in your system.
Yep.
So yeah.
And but the problem is,
so they have to comply.
If the European employee working in China, you have no choice. You have to use in the Chinese social platform.
Well, even in Europe, you still have WeChat.
WeChat,
yeah, you have that. You can use, a lot of people use that.
And nobody complain.
I mean, I haven't seen any case yet. I mean, there could be. I'm sure there would be, but I haven't seen it. And I mean, I'm just saying, when they operate on EU territory, they have to comply. That's it. So I don't think they are making any. They would make any exception because even one country may treat China differently, the other country wouldn't agree. So and it's at the EU level. So yeah.
For example, like when you're working for the Hong Kong government, you are helping them doing that stuff. But once Hong Kong is a hand to...
I was like, okay, we're doing what stuff?
Since Hong Kong is...
sensitive, exactly.
Yeah, back to the China, and then the Hong Kong government still practice that?
Okay, now at my time, I wasn't required to take oath being loyal to the party, right? I basically signed an employment contract, but remember, I guess before 2019, we were our legal system was mainly independent. I mean, technically it still is, but technically, I mean, or theoretically, you're still independent. But especially, I mean, personal data privacy ordinance of Hong Kong is the least they need to pay attention to, really. And honestly, we have been advocating on increasing not just the penalty, but also the authority. Like, for example, because like when I was there, I was responsible for self-inflicted investigation. So it's like if the data subject complains, it goes to my colleague. And then if nobody complains when we know about the incident, my team investigates.
Okay.
but we do not have search and seizure authority.
Okay.
So basically, we have to ask, please come and we would like to talk to you. I remember it was a very funny case. We found someone breaching a minor section of our law, right? So my staff needed to contact the controller and ask him to come into our office, and we need to interview him to talk to him. And he was practically hiding from us. I mean, he was like, we went, our staff like went to his office 3 times, and one of them even stayed there like half a day, and he just didn't show up. He never showed up to office. And then we really couldn't do anything. We almost couldn't do anything, right? But luckily, but because before I joined the commission, I was an entrepreneur myself, right? So I told my staff, well, you need to understand how bosses work. Bosses don't have to go to the office, but they have to go home. So what we did was because the law allows us to find the background of the controller, the owner of the company. So we requested the home address of the owner, right? So one morning I went with my staff to knock on the door at 8 o'clock in the morning. And okay, well, you are served.
It's really tough.
I mean, yeah. So this is what we had to do or have to do still. You know.
Yeah.
So
You actually raised a similar question. Is when we doing the data protection compliance for one of the university, and when we try to help them to do the compliance, the whole office they just turn the light off and close the door and lock it, and you cannot go in at all. It looked like a similar thing, huh? Well, anyway. But by the way, your last slide is because we have so many AI topic this week, But but your slide is talking about the AI Act. I really wonder. That is really interesting. You can think about it. I think most of you know that the Ukraine already using the robot dog in the Ukraine war fighting. Do you see that?
no, I didn't read that.
Okay, anyway, the Ukraine already using the robot dog.
I know that, but
Yeah,
I didn't read the
yeah. But I mean, is how the European Commission is going to work out this AI Act, and what they expect the consequence or the goal they want to reach.
Well,
Because the AI, the major development is not in Europe. The major development is in United States, in China, and
well, that's why they want to control it first before it comes in. I mean,
Well-
since I do not get to design it, and
Wait a minute. Is any European here? Okay. Can I talk about joke about European? Once upon a time when the people talking about GDPR, talking about the what's that, the Marketing Act, Digital Marketing Act, that kind of stuff, and AI Act. My personal feeling, this is my personal feeling, okay? It's not insult. No, just personal, okay? If you look at the internet development, the whole internet development in a global, who is the winner, who is the loser? Do you have any idea? From 1999 till now, which country is a winner? Which country is a loser in the whole internet development, particularly no matter in the business or the whole development? My personal comment: only 2 countries make a big profit for the internet development. One is called United States. Another one is called China. And who is the loser? I think the European is loser. and my reaction to this GDPR I'm thinking about is European thinking about I'm a loser. So I come with a GDPR. So now I come in to make a control you guys. Then Meta, Google, you pay me money.
I mean, correct me if I'm wrong, but I live in now. This summer, I've been living in Spain for 4 years, and we have business there. We have do other a lot of other things there. So my personal experience, exposure, I think it's like okay. It doesn't matter who. It's like geopolitics.
Yep.
I want my hands on this piece of pie first. Okay, so it's like, well, you guys are still debating in the U.S. We are a uniformed, entity. The EU, so we have something first. We come up with something. Maybe still early. It's definitely subject to revision or subject to improvement, but we have something. And so it's like you want to market your system in our territory.
Europe. Yep.
You have to do something. You have to come talk to us. Okay, we have this. It's not comprehensive. It's not complete, but yeah, come talk to us first.
And that doesn't mean the European can be turned from loser to winner, no?
I can't say that. I mean,
You don't know?
I don't know. I think it's, yeah. Question?
Okay, please. Come to the speaker. Microphone.
Just on that topic, I think that there's a book by Professor Anu Bradford who extensively argues that Europe as a continent has great regulatory capacity, while China has the great infrastructure that it is exporting, and while US has great market libertarianism and innovation and whatnot. So just to add to your terminology of losers, I think the losers here are the South Asians and the Asians whose data is being profiled, while we are the primary subjects of these big tech companies, right? Like we are the ones who are the primary consumers, the customers whose data is being taken and then being deployed against us, so to speak. But that sort of leads me to a question that I wanted to pose about national security exemptions that are now becoming increasingly prevalent in data protection acts within the South Asian region, at least in Bangladesh, India, Sri Lanka. We are seeing a lot of national security exemptions, which is a direct borrowing from the Chinese understanding of information and cybersecurity. So what do you think about that security versus safety debate within the data protection frameworks is now being more contextualized in terms of security and national security, and prioritizes security over safety of the data subject?
Well, like I mentioned earlier, on paper, like I said, the GDPR is trying to balance the two. Now, of course, it doesn't. This is part of the public interest and safety, but it does not rule over national security. Now, although I guess that depends on what level of national security you're talking about, because unfortunately, like in Hong Kong, anything is national security. You criticize the governor is national security. No, I'm kind of stuck. So should I be worried about my return flight?
For Taiwanese, we don't care.
Yeah, but I need to return. So I guess, but I guess in another perspective to answer your question is, for Western, like for democratic countries, this is often determined by the voters, the people, right? I mean, the reason I said that is even look at the US, right? After 9/11, what happened, right? Okay, now a few years later, so some people kind of, I don't know if some people woke up or actually just stirred up by the other side of the politicians, but okay, so things started to change again, and so okay, so we are kind of in a difficult situation. You know, we have so many wars going on, or physical and online, and even some that are imaginary, and so I guess this is time that your question becomes even more difficult to answer, and I guess we now if you go back to the European Union situation, I think at least in itself there are. I'm not saying it's ideal, but at least there are mechanisms between the European Commission, the CJEU, and then the different national level like laws, that they are kind of counterbalancing each other. You know, the advisory committee, you know, so. So hopefully we are not seeing, or at least so far we haven't seen that many situational cases that kind of working against ourselves or netizens.
Yeah, I just try to make my definition about a winner and loser. The reason I'm saying that is because once upon a time I looking around the global top 30. You know, market value company, okay? And you look at those of the, I think you can go to the Google type, top 30 global market value of the internet company. You'll find it about 60% is an American company, 40% is a Chinese company, you know, like Alibaba. They really make a lot of money at the time, you know. So you don't see the European, you don't see the Japanese company, you don't see the Taiwanese company. It's the whole top 30. It's incredible. It's almost an American company or Chinese company. You know, so I just make my definition clear for you, you know. So anyway, any further, please? The European coming to
yeah, the European came. Hi, I'm Elia, and I'm a youth ambassador on the Internet Society. So a small comment, and then I will proceed to the questions. So what we were saying before about Europe is true. We are providing much more policies and regulations that we can implement, and AI Act is the biggest example of that. Because, for example, it is a really wide text, thousands of pages about high-risk systems, and Europe doesn't have many high-risk systems. It's like the 25%, and the majority of these obligations are dedicated to that, which doesn't make any sense. They are providing regulations just to say that they provided something. That's my honest opinion. And about the questions, I was thinking before we were talking about GDPR. For example, if I'm the data subject and you are the controller, and you have the legitimate interest of processing my data, and I don't give the consent to do that, you can still process the data?
Yep.
That was
Well, I'm required to, I mean, if I were the controller, I'm required to request consent, explicit consent. And it's not, and I cannot hide it in fine prints. I cannot even, you know, the Italian telecom, that company that I was mentioned, that was fined €1 million. They were defending that they actually had legitimate interests in processing those data, but it was rejected. And so, because obviously, you know, you making marketing calls to your customers, of course you have legitimate interest, but it's not the interest of your business operation. It's not like you're not required to do that. You won't bankrupt the next day if you don't make these calls. And technically speaking, you also have the time and capability to check no-call list before you make these calls. So yes, so you have to, I mean, because part of the victims, or some of the victims, in that case, they did not give consent. So those were like direct violation, and then some did give consent, but they were still on the no-call list. So so they consent that they can process the data to collect the data, but that doesn't mean that you can call me. So because all this processing, the purpose of it must be specific, must be specified. Yes.
As a European, you should be proud of it, because that means your government care about you, your right. And I think this is the end of this session. And before we say thank you to the Chester, remember in the next session we will have digital civilization from the Jun Murai. Jun Murai is the internet father of the Japan, so you are coming, and let's give the Chester a big applause.